Hello, everyone, and welcome back. You remember me? I'm Patrick McGinley. I'm a member of the Florida Bar. I'm a member of the District of Columbia Bar, and I defend my fellow lawyers against bar grievances, ethics complaints, and help them solve ethics problems. And that is why I am speaking to you today. I am continuing our lecture regarding conflicts of interest. Specifically, I'm talking about some difficult conflicts of interest, so difficult that at least in the model rules, they're identified by name. And in many jurisdictions, they remain identified by name. And for some, if not most, of these particularly sticky and difficult types of conflicts of interest, there are specific solutions that are mandated by the rules for you to follow if you happen to find yourself either in one of these conflicts of interest or involved toward the potential from one of these conflicts of interest. They're that important that they're identified in the rules. And so we dedicate an entire lecture to these particularly difficult situations. Now, although these are particular situations and situations of particular difficulty, nevertheless, they are bound by and decided by the same rules that apply to any conflict of interest. So let's take a quick look at where you're going to find those general rules. Then let's do a quick overview of the general rule. Once we've done those two things, let's look at these particularly sticky situations one by one and identify the specific solutions. First, to begin at the beginning, where do we find most of these rules? And your jurisdiction is probably like the majority of jurisdictions. You're going to find them in Chapter 1 of your Rules of Professionalism, where the lawyer-client relationship is discussed. You'll probably have something like Rule 1.7, which is the general rule for conflicts of interest and was the topic of our last lecture. We're going to give you a quick overview of what you learned in that last lecture, because that's the general rule that still applies today when we talk about Rule 1.8. Rule 1.8 is that particular rule that identifies these particularly sticky situations that are specifically addressed in today's lecture. But you also find guidance in Rule 1.9. This talks about duties to former clients. You find guidance in Rule 1.10. This talks about that imputation of conflicts of interest, where the conflict is imputed to you and the rest of your firm, even though it was just one lawyer or a different lawyer who had the actual conflict. You might suffer from the imputed conflict. That's Rule 1.10. Rule 1.11 gives us some guidance of special conflicts of interest for former government officers, current government officers, former government employees, and current government employees. And Rule 1.13 talks about the organization as a client, but that's particularly important here because if the organization is your client, then there may be a potential for a conflict of interest that wouldn't exist otherwise. So that's the forest. To look now specifically at the trees, remember Rule 1.7 is the general conflict of interest rule. So let's review it again. We talked about it already in great detail, but let's review it again because the specific and difficult conflict of interest scenarios, that is the topic of today's lecture, they're still governed by this general rule. So we've got to know it and understand it. To paraphrase the general rule, and in your jurisdiction, it's probably been rephrased from the model rule because with all due respect to the hardworking folks who drafted the model rule 1.7 is quite inartful. So what we have on your screen here is my paraphrase of that inartful rule. To paraphrase it, without a waiver, a lawyer can't represent a client in either of these two situations. The first is the one highlighted now. Without a waiver, a lawyer shall not represent a client when representing one client is directly adverse to another client. Or, without a waiver, a lawyer shall not represent a client when there is a significant risk that the lawyer will be materially limited by the lawyer's responsibilities to another client, or to a former client, or to a third person, or to a personal interest of the lawyer. In either scenario 1 or scenario 2. If you don't have a waiver, you can't represent the client. Let's take a closer look at scenario 1, specifically what's meant by directly adverse? We know that without a waiver, a lawyer shall not represent a client when representing one client is directly adverse to another client. But what does directly adverse mean? Directly adverse and its definition, we can extrapolate from the official comments to the model rule, and we can extrapolate a slightly different definition in a litigation context versus what you might see in a transaction or transactional work. First, in a litigation context, directly adverse means advocating against. If you're advocating against in that litigation, then you're directly adverse. That would include suing or bringing a claim or a cause of action against your client. But it includes more than that. If you're just cross-examining a client, if you're doing something that's damaging to a client, that's directly adverse. What's not directly adverse? Economically adverse is not directly adverse. The example we gave in our detailed lecture earlier talked about competing bids. Long story short, if it's just an economic adversity, under the model rules and under the rules of most jurisdictions, it will not meet the definition of directly adverse when it comes to litigation. But what does directly adverse mean when it comes to transactions or transactional work or non-litigation contexts? There, directly adverse means negotiating for. So for example, even if there's different transactions, you're representing the buyer now, and in the second or subsequent transaction, you're representing the seller, but the buyers from the old transaction is also in that second or subsequent transaction. Well, that's going to be directly adverse in a transactional work context. What's not directly adverse? Again, if it's merely economically adverse. And as you remember from our detailed lecture that you already experienced, we had the example of separate offers. So that's the meaning of directly adverse when it comes to Rule 1.7. But now another phrase we wanted to define was materially limited. We want to define the phrase materially limited because we know that without a waiver, a lawyer shall not represent a client when there is a significant risk that the lawyer will be materially limited by the lawyer's responsibilities. So what does materially limited mean in that context? It means interferes with the lawyer's independent judgment. The lawyer must have the ability to have independent judgment. So that's what we're looking for here. That would include being unable to take an appropriate course of action. If you can't do that thing that you know is appropriate for that client, that's interfering with your independent judgment. That is a material limitation. What would be excluded? And again, the mere possibility of subsequent harm, as we talked about in greater detail in that lecture, that's not a material limitation. If it's merely a possibility of subsequent harm, the lawyer is not materially limited. So that's the definition of materially limited when we talk about the general rule of conflict of interest. All of that was true if there wasn't a waiver. What about a waiver? Can you get a waiver? That's the first question. Waivers aren't always available. And when they are available, they've got to be done correctly in order to be effective. When is the waiver available? If you're neither litigating a claim against your client nor prohibited by law, and the lawyer has a reasonable belief that she'll be competent and diligent despite the conflict, that's when the waiver is available. How is the waiver done correctly? To state it most succinctly, it's done correctly if a writing confirms the affected client's informed consent. But wait, there's more. There's a lot there. First of all, what is informed consent? We've got to know what it means for the consent to be informed. What is informed consent? To define the phrase informed consent, we would say that it means with knowledge of two things, with the client's knowledge of the risks of waiving that conflict, and with the client's knowledge of the reasonably available alternatives to waiving that conflict. So those two things, risks and the available alternatives. Those are the things we talk about when we talk about a consent that is an informed consent. But we need more than just the informed consent. We've got to confirm it in writing. What's a writing? Under the model rules, a writing is defined in Rule 1.0. To paraphrase that definition, it means anything given or transmitted to the client other than an unrecorded verbal utterance. So some examples would include an email, would include a text message, would include an SMS, would include one of Twitter's tweets, would include one of Facebook's instant messages, would include a video if you can transmit it to the client, would include a handwriting. Remember the old pen and paper? Still exists. A handwritten note handed to the client. That would constitute a writing. What's excluded with such a broad definition of Rule 1.0? Not much. But basically, if you can't retransmit it to the client, such as some spoken words that you have not recorded, then that would not be included in the definition of a writing. Now, this writing, when must it be transmitted to the client? It must be given or transmitted to the client promptly, says the rules. But the rules do give you a little bit of wiggle room insofar as if it's not possible to do it promptly, then you can do it within any time that is reasonable under the circumstances that prevented it from being done promptly. See Rule 1.0 for more details on that. So that's our general rule again, and it comes typically from Rule 1.7, check your jurisdiction. You may have renumbered it. Texans, it's renumbered to 1.6. Fellow DC bar members, it's 1.7. Fellow Florida bar members, it's Rule 4-1.7. Check your jurisdiction and you'll see that the general rule for a conflict of interest regarding current clients is found there. So when we turn now from 1.7 to Rule 1.8, I would argue that what we have is a list of difficult circumstances where the application of Rule 1.7 is clarified and further details are given. Arguably, these are not separate rules insofar as they don't replace or they don't mean that 1.7's general rule doesn't apply. It's just that under these particular circumstances, the details of Rule 1.7 require a little bit more. In order to fully comply with 1.7, in these particularly difficult circumstances, you need to do just a little bit more. I think that's the way to look at this. So what I'm trying to say is don't throw away your knowledge that you gleaned from studying Rule 1.7. Rule 1.7 is still the general rule and still the rule of thumb as we get into these sticky situations one by one that are enumerated and addressed in Rule 1.8. 1.7 still applies, but 1.8 tells us how it applies. I think that's the best way to read Rule 1.7 and Rule 1.8 in harmony. So with that preface, let's take a look at some of the things that we find in Rule 1.8. And I'll move through them a little bit quickly. The reason I'll go a little bit quickly is the logic, the policies behind it. We've already covered those when we cover Rule 1.7's general rule. To no small effect when it comes to each and every one of these difficult situations in Rule 1.8, you simply have to memorize them. Perhaps you're such a genius that you would have come up with the exact solution identified in Rule 1.8. Good for you. For the rest of us mere mortals, we're going to have to memorize what we see enumerated here at 1.8. So I'll try to slow down a little bit from this point forward. But keep in mind, ultimately, it's not a question of me giving you more logic. It's more of a question of you memorizing what the rule says. So here's the answer for the sticky situations that we find enumerated in 1.8. Let's start with A, shall we? A would involve money. Specifically, A would involve a business or a business transaction or an economic interest. What we're talking about here is when you're transacting business with the client. Maybe you're going into business with a client. Maybe you and a client are investing in the same thing. Or maybe you're neither going into business with nor investing in the same thing. Maybe it doesn't have to do with business. Maybe it has to do with an economic interest that you yourself are acquiring independently. Any of those scenarios fall under this rule A. So perhaps you and your client are going to get together and buy something. That falls under rule A. Perhaps it has nothing to do with your client. You're going to buy it on your own. Still, rule A applies. So rule A talks about either transacting business with or acquiring an economic interest. And if that economic interest is adverse, if it's against your client, then these are the rules you follow. So when do you follow these Part A rules? You and your client have teamed up and you're buying or investing. Rule A applies. You're buying or investing without your client, but what you're buying or investing in can become adverse to your client. Rule A applies. So in any of those scenarios, rule A applies. And what's the solution? How does the conflict of interest rule get solved in any of those economic situations? First, the terms have to be fair to the client, have to be reasonable to the client, and have to be fully disclosed to the client. All three of those requirements, fair, reasonable, fully disclosed, are viewed from the perspective of the client. So is the deal fair and reasonable to you? Well, I presume so. You wouldn't be spending your hard-earned money otherwise, right? That's not what the rule is talking about here. It's talking about from the perspective of the client and fully disclosed. You might think, well, it's my investment. It's my money. It's my financial privacy. No, not from the perspective of Rule 1.8, subsection A. There, you have a duty of disclosure. But there's more. You also have to tell the client in writing to go seek independent counsel, and you have to give the client time to actually do that. Told in writing and given time to seek independent counsel. That's the second requirement. The third requirement, after the terms are fair, the terms are reasonable, the terms are fully disclosed, you've told them all that in writing, you've given them time to seek independent counsel, now you have to obtain their informed consent. And you remember from our lecture talking about Rule 1.7 exactly how and what a client needed to be informed about and what it takes for that consent to be informed consent. That requirement, again, it's here. And fourth, you're going to need the client to pick up a pen, or I guess an electronic signature, and sign, because you need a signed writing. That signed writing's got to state the essential terms of the economic transaction. It's got to state what the lawyer, what your role as lawyer is in that transaction. And specifically, it's got to identify whether you are representing this particular client and that particular business transaction or economic interest. So they got to know more than just you're involved. They got to know whether you're involved as their lawyer. That's part of the requirement of number 4. So if you're going to transact business with or acquire an economic interest against the client, it's got to be on terms that are fair, reasonable, and fully disclosed. You have to tell the client in writing to seek independent counsel, give them time to do so. You have to obtain the client's informed consent, and ultimately you've got to have, and you've got to save, and you've got to keep that signature, your client's signature, on a writing where the writing says the essential terms, where the writing says you as the lawyer, what your role is in this business or economic transaction, and clarifies whether you are serving as that client's attorney in this business or economic transaction. That's all the things you'll need in those scenarios. So that's scenario A. Let's turn now to scenario B. Scenario B is when you are attempting to use information, knowledge, data against your own client, when that information, that knowledge, that data is relating to your representation of that client. That's a clear and obvious conflict of interest, isn't it? How can you do that? Well, in order to use information relating to representation of your client against your client, you're going to need either informed consent. Remember all the requirements of informed consent under Rule 1.7. You need them all here. Or you're going to need a rule of professional conduct that permits you to do that. There are times where the rules of professional conduct in your jurisdiction are going to allow you to use information relating to your representation of your client against your client. A typical example, and surely one that exists under the rules regulating the Florida Bar and the DC Rules of Professional Conduct, is when the client has filed an ethics complaint and grievance against you arising out of your representation of that client. In such a situation, you don't need informed consent. You can use information relating to your representation of that client who has filed an ethics complaint or bar grievance against you in order to defend yourself against that client's bar grievance or ethics complaint. That is just one example of number 2 of a rule of professional conduct permitting you to use information relating to your representation of your client against your client. There are other examples in the rules of your jurisdiction. When such a rule applies, then you can use information relating to your representation of your client against your client. But make sure it's on all fours. Make sure you've dotted your I's and crossed your T's. Make sure that that rule actually does apply. Look before you leap, because that's an exception. So the burden's going to be upon you to prove you're entitled to that exception. That's scenario B. Let's look now at scenario C. Scenario C talks about gifts, gift giving, happy holidays, happy birthday. People love to exchange gifts at certain times of the year. A client may be appreciative of you. A client might want to include you in the gift giving. What I'm talking about here is soliciting a gift from your client. An unsolicited gift, hey, those things happen. And that is going to be a scenario not specifically covered under scenario C, but certainly one that's going to give rise to professional responsibilities. For example, if you're part of a law firm, can you keep the gift for just yourself? Or does that include part of the revenue of the firm? Whether or not you solicited the gift, more often than not, it's going to include revenue. A gift probably will be considered revenue under your employment agreement. You're going to have to clarify that with your employer or your partners. But what about soliciting a gift? What about trying to get a gift from your client? Again, whether you solicit it or not, you're working for the client, so it's going to count towards the fee. Remember our prior lectures about attorney fees and how the amount of the fee is always a matter of ethics, how it has to be reasonable, how it can't be unconscionable. Watch out for even an unsolicited gift turning a fee into something beyond reasonable, perhaps even into the realm of unconscionable. Watch out for that issue. That's true whether the gift was solicited or not. And those are two issues that apply regardless of whether or not there's a conflict of interest. Those are tangential, however, to this subsection C, to this example C, where I'm talking about soliciting a gift from your client, or I'm talking about preparing an instrument, a will, a trust, an estate plan, a contract, any kind of instrument where, as part of that instrument, you get a gift from your client. So I'm talking about actually getting a gift. I'm talking about soliciting a gift. I'm talking about preparing an instrument giving you a gift. Now, what do you do? How do you avoid the conflict of interest in these two scenarios? Soliciting a gift or preparing an instrument giving you a gift. In either of those two scenarios, Here's how you avoid the conflict of interest. First, you're related to your client. All this is okay, this gift giving, if it's out of a loving familial relationship that is family. The definition of family might be defined in your rules and your jurisdiction. Certainly under the model rules, they urge all jurisdictions to have a very open-minded definition of family that goes beyond mere blood relationship or relationship by genetics or blood. So check the rules of your jurisdiction to see whether or not you're related. If you're related, then you can solicit a gift. Hey, mom, give me a Christmas present. That's okay. Not a violation of the rules of professionalism. Likewise, you're preparing a client's instrument. You're writing mom's will. You're writing dad's estate plan. That's okay because you're related to the client. The other alternative is if the recipient is related to the client. So, for example, you have a spouse. You're writing the in-laws will, trust, your estate plan. And it's going to include the in-laws, your mother-in-law, your father-in-law, leaving something to your spouse. That's okay. You'll meet the exception of 1.8 sub C. So there you have it. If you're either going to solicit a gift or you're going to prepare a client's instrument giving you a gift, make sure that the client is either related to you or related to the recipient. Let's look at scenario D. Scenario D talks about making some money off your client's story. You know, as a lawyer, everyone loves, as a lawyer, to tell those war stories, to tell those stories of the great victories, to tell those stories of the transactions that were done so well by you as a lawyer, to tell those victories in the courtroom. What we're talking about here is telling those stories for a profit. Talking about writing the book, talking about writing the script, turning it into a movie, turning it into a play. Sure, great theater. Turn it into the YouTube video that gets posted. Hey, is that this? No. I'm talking about a client story that's included in the YouTube video that is posted. Now, and with economic gain here, is what we're talking about. We're talking about making money off the book, making money off the movie, making money off the story rights to your client's case or situation. In order for you to do that, you've got to do either one of these two things. You got to negotiate for the right to make the profit off the client's book, movie, or story rights after your representation ends. So you're done representing this client. The case is over. The withdrawal is complete. You no longer have this client as an active current client. They're just a former client now. They've moved into the former client category. Now's the time to negotiate for the right. Don't negotiate for the movie rights before this client becomes a former client. The client has to be firmly in the former client category before those negotiations can ethically occur. The other alternative here, we can extrapolate this from the model rule, the comments there too, is that you can tell the story without your version of the story being substantially based upon information relating to the representation. In other words, don't tell a true story. Tell a work of fiction. Even if that work of fiction is inspired by a true story, so long as you're telling that story without your version of the story being substantially based upon information relating to the representation, then you're okay to do that and make money off of that book, movie, or story rights. So you're going to have to change reality sufficiently so that your work of fiction is no longer substantially based upon information relating to that representation. So maybe, you know, you had a great story, but when you sit around and you start to tell that fish tale, you know, one of those tall tales, the fisherwomen, fishers out there might be able to relate to this. You know, when you caught that fish, you're proud that it was 10 inches long. And then a few years later, it was 11 inches long. And after telling the story for a few more years, it was 14 inches long. And well, suddenly after a couple of years, wasn't it 17 inches long? You know, sit down and tell a fish tale. Take the client's real life story that was 7 inches long and make it 14 inches long. Expand upon it. Elaborate upon it. Fictionalize it to such a degree that the end result is no longer substantially based upon information relating to the representation, and then boom, you've complied with your responsibilities to avoid a conflict of interest regarding a current client. So that's scenario D. Let's look at scenario E. Scenario E talks about giving money to your client. And hey, there may be times, depending on the type of client, where this is something your heartstring is being pulled upon. It's something you might want to do. Oh gosh, depending on a particular client and how bold they are and how needy they are, they might actually ask you for money. But you have to keep in mind that in most situations, it's unethical for you to do so, because doing so is a conflict of interest. It is. It's a conflict of interest under most rules of professional conduct in most jurisdictions. So when is it not a conflict of interest? When can you give money to a client? To give money to a client, it must be either court costs advanced and repaid, and maybe the repayment isn't a certainty. It's okay as long as it's court costs. If it's just a contingency, maybe getting repaid is contingent upon victory, or contingent upon a successful settlement, or contingent upon your client seeing a recovery from which your client can pay you the court cost. That's okay. You can give money to your client if you give it to them in kind, not cash, insofar as you're paying the cash to a third party and you're paying it because it's a court cost and you're advancing that cost, even if it's only contingently being repaid to you, so long as the potential is there for your repayment and it's not directly to the client, it's to a third party in the form of a court cost, then that is okay. Here's another scenario where it can be okay. Court costs and litigation expenses of an indigent client. So here, there isn't even the potential for contingent repayment. You know you're not going to be repaid, but this particular case involves your particular client, where your client meets your jurisdiction's legal definition of indigency, and your jurisdiction will have such a legal definition, because in your jurisdiction, there will be, for certain cases, an exception to the courthouse's filing fee when indigency can be proved. Under that legal standard in your jurisdiction, if your client meets that legal standard of indigency, then you can advance those court costs and litigation expenses, even the ones you don't even have a contingent chance of being repaid. Another scenario where you can give money to your client is if it's reasonably necessary to permit your client to institute or maintain litigation or an administrative proceeding in the District of Columbia, and you are a member of the District of Columbia Bar. What? Okay, very narrow exception, isn't it? You are going to have to be, like me, a member of the DC Bar. And the client's case, whether it's a potential case or an active case, has to be a litigation or an administrative proceeding that's going to be filed or is filed in the District of Columbia. Why do I even point this out, so narrow an exception? Because I'm a proud member of the District of Columbia Bar, and I think they've made a wonderful and inspiring exception to this general rule. And if you don't believe me that it exists, go ahead and pull up your own copy of the DC Rules of Professional Conduct, and you will find it there under Rule 1.8 sub D, which reads as follows. For my fellow DC Bar members, while representing a client in connection with contemplated or pending litigation or administrative proceedings, a lawyer shall not advance or guarantee financial assistance to the client except that a lawyer may pay or otherwise provide, 1 and 2. 1, The expenses of litigation or administrative proceedings, including court costs, expenses of investigation, expenses or medical examination, costs of obtaining and presenting evidence, and 2, other financial assistance, which is reasonably necessary to permit the client to institute or maintain the litigation or administrative proceedings. So there it is. That's not the general rule. That's not the model rule. That's not even the majority rule in the majority of jurisdictions. What that is a rule of professional conduct in the District of Columbia. That's why I spell out very specifically here, number 3, that it's reasonably necessary to permit your client to institute or maintain litigation or administrative proceeding in the District of Columbia, and you are a member of the DC Bar. Think about what that rule allows you to do. It once happened to me that I was bringing a civil rights claim on behalf of an obviously worthy and obviously aggrieved client of mine who was the obvious victim of that civil rights violation. And the defendant, in my opinion, obviously guilty, was also, as best I could tell, financially solvent. So at least in my humble opinion, in that particular case, which will remain anonymous, I thought my client deserved to win. I thought my client was going to win. And I thought my client was going to recover. And we had a settlement offer made to us. It wasn't exactly a lowball offer, but it wasn't exactly a generous one either. I honestly believed I would win more if we went the distance. And more importantly, I honestly believed that if we kept on litigating, they might even make us a better offer down the line. Easy for me to say. My client, however, was behind on the rent. She decided to take the settlement. Man, that was a Florida client in a Florida case. I wish it had been a District of Columbia client in a DC case. I would have loved to have been able to say to her, hey, I'll loan you this month's rent money. Just let me work this case a little bit longer. But I couldn't say that as a Florida lawyer to a Florida client who had a Florida case. That would have been a conflict of interest. That would have been a violation of the rules regulating the Florida bar. Even though, had the facts been different and the jurisdiction been different, that would not have been a violation of the DC rules of professional conduct. I honestly believe that what the District of Columbia Bar has done here with their particular carve-out number 3 on the big screen protects the public without invading the independent judgment of the lawyer. I believe what the DC Bar has done is a good thing. I don't know if perhaps it's appropriate in your jurisdiction or not, but I would like you to strongly consider whether or not it is. You often see advertising, especially in a personal injury standpoint, where the personal injury firms of all jurisdictions either state or at least imply that since they're such a big and powerful firm, they've got the finances to help you better than they could if you went with a smaller or less powerful firm. And is that even true in a jurisdiction where you don't have a rule like this? Obviously, in those jurisdictions where you don't have a rule like this, those big personal injury firms say it. But can they honestly mean it? With a rule like this, they could. Now, I know champerty, separate maintenance. I know the history of trying to avoid letting lawyers have too great a financial interest in the litigation because that prompts lawyers to continue litigation. I know public interest favors settlements. I know all those things. So maybe you might argue that this particular carve-out goes a little too far. Maybe you might argue that it allows litigation to last a little bit too long. And perhaps in a particular type of case or in a particular jurisdiction, maybe you're right and maybe the District of Columbia is wrong. But this is a conversation, in my humble opinion, that every jurisdiction should be having as to whether or not an exception like DC's number 3 that you see on the big board here, whether or not that's appropriate in your jurisdiction. I think That's worth talking about. So forgive me if I was standing on my high horse or up on a podium or being holier than thou there for just a minute, but I think it's an issue worth talking about. And so I took the time to do it. Hope I didn't waste your time in discussing that. And that's a fair summary of the exceptions. These are the exceptions you see under Rule 1.80. But let's talk about scenario F. What's scenario F? Scenario F involves a conflict of interest that can arise based on where the money came from. Specifically, I'm talking about you as the lawyer accepting payment for you and your legal services from someone who is not your client. Can you do that? Yes, you can if you do it properly, but you've got to do it properly because look at the risks that can be involved there. To accept payment for your legal services from someone who is not your client, and to do that ethically, you must do these things first. You must do these things before you take the money. You must first, number one, obtain your client's informed consent. Don't forget our earlier lecture about all the details and all the requirements that must be satisfied for your client's consent to be considered informed consent. The first of these list of requirements, all of which are required for you to accept payment for your legal services from someone who is not your client, begins first with you obtaining your client's informed consent. The second thing is that you must make sure it must be true that it won't interfere with your relationship with your client. That's a factual inquiry that varies based on case by case. Some clients may not care as long as your legal fees are satisfied. Other clients may very much care where this money came from. Some clients don't want to be beholden to others. Some clients take offense to public assistance. Some clients don't want their legitimate debts to be satisfied by another. And those three examples are just some of many possible scenarios where accepting payment from someone other than your client might interfere with your relationship with your client. If it will interfere with your relationship with your client, then you cannot accept payment for your legal services from someone who is not your client. And another on this list of requirements is that it must not interfere with your independent professional judgment. Again, I hearken you back to our detailed lecture on Rule 1.7, and we talked about material limitations and being materially limited and how you've got to have your own professional judgment intact, unaffected by any third party or personal interest. Here, there's a potential for your independent judgment to be affected if your client's legal services are paid by someone else. For example, say your client has insurance. Perhaps that insurance contains a duty to defend, by which we mean in the insurance world that the insurance company has to pay for a lawyer for the insured. The insured doesn't have to buy their own lawyer if there's a duty to defend. But what if the insurance company only hires from a panel of lawyers, hand-selected by the insurance company? Perhaps they've been hand-selected not just for their skills, but for their willingness to work cheaply. Likewise, what if the insurance company wants the experts in the case to come from the approved panel, who again have been chosen not just for their expertise, but for their willingness to work cheaply? What if the same is true of the court reporters? What if the same is true of the vendors? These things could, maybe they won't, but they could interfere with the lawyer's independent judgment. That's a case-by-case inquiry. We can't per se say that we can never have an insurance company panel of lawyers. We can't per se say that we can never have approved vendors from the insurance company list. But when those things exist, which nowadays more often than not they do, we have to examine on a case-by-case basis to make sure that this doesn't interfere with the lawyer's professional independent judgment. No material limitation. So there's three things you've got to do in order to accept payment for your legal services from someone who is not your client. But there's a fourth. You have to remember the duty of confidentiality, a duty that exists in favor of your client, regardless of who paid your client's legal bills. So just because you've been paid by a third party doesn't mean you share secrets and confidences with that third party. For example, it's not uncommon if a minor needs legal services. For example, a 17-year-old who's been arrested for shoplifting. It's not uncommon for a parent or a guardian to be the one paying the legal fees. So young little Susie was shoplifting. Young little Susie has $12 in the bank. Young little Susie's mom might be paying young little Susie's legal bills. But keep in mind that the client is young little Susie. The duty of confidentiality runs to the client and remains confidential, regardless of who pays the client's bills. So to accept payment for your legal services from someone who's not your client, that person should understand that that doesn't mean they're going to get perfect information. So there's a scenario with a parent and child where that might exist. Let me give another example of a scenario coming back to the insurance companies. You know, it was decades ago where the American Bar Association came up with their LEADS, LEDES, and their UTBMS codes. These LEADS and UTBMS codes are used by those insurance company lawyers who are doing insurance defense to code their invoices. Code line by line each time entry. Why? So that the invoice can be reviewed. Reviewed for what? Reviewed for potential reductions. You know, maybe the lawyer billed 0.2, but the insurance company doesn't want to pay 0.2, they want to pay 0.1. Maybe the lawyer billed 0.1 hours, but the insurance company doesn't want to pay 0.1, it wants to pay 0. You know, the insurance companies, more often than not, are reviewing legal bills, and it's not uncommon that they might outsource that service to a legal bill review company. Is this the disclosure of confidential information? Again, it's going to depend on a case-by-case basis. It's going to depend on that particular litigation. It's going to depend on that particular bill. It's going to depend on that particular time entry. A time entry as vague as telephone conference with client doesn't reveal as much confidential information as a time entry that reads telephone conference with client where we discussed how a $12,000 settlement would be favorable, but they want at least $15,000. Comparing those two time entries, you can see how the legal invoice may or may not disclose confidential information. But the bottom line is this: all four, 1, 2, 3, 4, all four are required to accept payment for your legal services from someone who is not your client. You must first obtain the client's informed consent, and you got to make sure it doesn't interfere with your relationship with your client, and you got to make sure it won't interfere with your independent professional judgment as a lawyer. And you got to remember, and they've got to understand, that you won't disclose any confidential client information. So that's scenario F. Moving on from scenario F, let's look at scenario G. We're talking about here one lawyer, many clients. One lawyer who in the same lawsuit or transaction represents more than a single client. Specifically, we're talking about a lawyer who represents more than one defendant. So 2 or more defendants in the same civil suit, or 2 or more defendants in the same criminal defense suit, or 2 or more defendants in the same administrative law action. To settle any of those cases where you as the lawyer represent more than one defendant, here's 4 things you've got to do. First, you've got to obtain each and all clients' informed consents. The majority of the clients, not enough. All but one client, not enough. You've got to obtain each and all clients' informed consents. And you've got to get each and all clients to sign a writing. And you've got to disclose each settlement's terms to each and all clients. No secret terms, no deal on the side, no term that applies to one and to all, unless You've disclosed all of that to each and to all of the defendants that you represent. And ultimately, you've got to disclose to each and to all of the defendants that you represent whether or not the other defendants accepted the deal. So all four, to settle a case where you represent more than one defendant, you've got to obtain each and all clients' informed consents, get each and all clients to sign a writing, disclose each settlement's term to each and all clients, and disclose to each and all clients whether the other accepted a settlement. There you go. Let's talk about scenario G. Oh, already did that. Let's talk about scenario H. Let's talk about scenario H. Scenario H, we're talking about settling an allegation or a potential allegation of malpractice. So maybe you already represent the client and there's an allegation of malpractice. Or maybe you haven't started representing the client, or you have, and you want to minimize the client's potential future malpractice claim. So this applies, for example, if you're talking to a potential new client and you've got a contract for hire, and in that contract, you're asking them to bring any alleged negligence or malpractice claim to arbitration instead of to court. Or maybe you're asking them to bring it to arbitration before you go to court. Or maybe you're somehow limiting in advance their recovery for a future claim of malpractice. All of those scenarios would fall under this rule. Also under this rule would be that you've begun the representation and now there's an allegation of malpractice. So in all those scenarios, this subsection H applies. It tells us this: to settle your client's current malpractice claim or to waive or minimize a client's potential future malpractice claim, you must get your client independent counsel if you have not already allegedly committed the malpractice, or you must give your client written advice to have independent counsel and a reasonable opportunity to get that counsel if you have already allegedly committed the malpractice. Now, I put it up on the board like this because it kind of seems almost counterintuitive, right? Wouldn't you think, well, if there's an allegation of actual malpractice, that would be the time where the client needs the independent counsel? And no, under the model rule, it's the opposite. So it's a potential new client. You haven't done a lick of work. Couldn't possibly be any malpractice because you haven't done any work yet. And there certainly isn't an allegation of malpractice. That's when they need actual independent counsel. Later, they're already a client. You've done some work. They're accusing you of malpractice. They don't have to have independent counsel. You have to give them written advice that they should, and you have to give them a reasonable opportunity to follow that written advice that they should, but ultimately they don't have to. Almost seems counterintuitive, right? But that's a correct summary of the rule. And as I warned at the very beginning of this lecture, for some of these difficult scenarios, you simply have to memorize it. This might be one of them. Because I don't know about you, but if I didn't know this rule and I was going to guess, I might guess differently. So when it comes to professionalism, we don't want to guess wrong. If what you've got to do is memorize, then that's what you've got to do. So here's the rule. Write it down verbatim if you have to. Memorize it if you must. And don't violate it, of course. Follow it. Follow it at all times. That's how the conflict of interest is solved when it comes to this scenario in Rule H. Let's look at Rule I. What about a conflict of interest that arises from you obtaining an ownership interest in the subject of the litigation? And maybe you're litigating over ownership of a business, and then you swoop in and you buy it yourself. There's a conflict of interest there, right? Maybe you're litigating over ownership of a piece of land, and then you buy the piece of land. That's potential conflict of interest, right? The rule is this. As a lawyer, you cannot obtain an ownership interest in the subject of the litigation, except for these three things. Except you can use a law or rule that permits you to impose a lien for fees. And, or, you can work for a contingent attorney fee. And, or, you could agree to the contingent recovery of your litigation costs that you advanced and paid. Now, you can do one or both or all three or none. The first one there, using a law or rule that permits you to impose a lien for fees, what is that talking about? Well, if you've practiced law for any period of time, you've encountered a situation where you didn't get paid. What do you do in such a situation? Under the laws of your jurisdiction, more likely than not, one of your options will be to impose a lien upon certain types of litigation. For certain types of litigation in certain jurisdictions, that's permitted. What that means is you've got some paper in the court file that creates an obligation for those that are in the litigation when there's a settlement to come knocking on your door and to talk about how much you get out of the recovery, the judgment, the settlement, the money obtained in that litigation. This is not true in every type of litigation. This is not true in every jurisdiction, but in certain types of litigation, in certain jurisdiction, it can be true. Arguably, that means you've got an ownership interest in the subject of the litigation, but that is okay because it meets this first exception. Working for a contingent fee is the second potential exception, and because you sat through more than 5 hours of lecture from me about attorney fees, you know exactly what I'm talking about there. And likewise, in those lectures, we talked about litigation costs. You can agree to the contingent recovery of your litigation costs. That's not a violation of the general rule against obtaining an ownership interest in the subject of the litigation. So those are the three exceptions, and that is scenario I. Let's look at scenario J. Let's talk about sex. You can't have sex with your client in most jurisdictions. Not every jurisdiction has this rule. You can't, District of Columbia, I'm talking to you, you don't have this rule. In most jurisdictions, you can't have sex with your client in certain circumstances unless you were having a sexual relationship before the attorney-client relationship began, or the client with whom you're having sex is a client of your partner attorney or your associate attorney, but not specifically your client. Am I really? Is this what I'm talking about here? Really? I'm done. I don't know about you, I'm done. All right, hey, thanks. Thank you very much. Thanks for putting up with this lecture. Please have a great day. Until our next lecture, may God continue to bless us all. Thank you.